Hello, and welcome to our Shriver Hangout for December 2015. My name is Amanda Moore, and I'm the Director of Online Content and Communities at the Sargent Shriver National Center on Poverty Law. I'm very excited to have with me today not one or two or even three, but four very esteemed guests. I have with me Gil DeFord. He's the Director of Litigation at the Center for Medicare Advocacy, and Gil's joining us from Cambridge, Massachusetts. Hello, Gil.
Hello. Hi, Amanda.
Hi. We also have Jane Perkins. Jane is the legal director at the National Health Law Program, and she's joining us from Carborough, North Carolina. Hello, Jane.
Hi, good morning, everybody, or good afternoon, as the case may be.
Exactly. It's a tricky time of day. And we also have Gary Smith. Gary's the Executive Director of Legal Services of Northern California. He's joining us from Sacramento. Hi, Gary.
Hello. Good to see you.
And also in Sacramento, we have Mona Tawatau. She is a senior litigator at the Western Center on Law and Poverty. Hi, Mona.
Hi, Amanda. Hi, everybody.
Well, these four guests of mine are the authors of our current Clearinghouse article. It is called The U.S. Supreme Court's 2014 Term, High and Low Profile Decisions with Lurking Access Issues. And this is the latest in a series of annual articles that we publish, always taking a look back at the previous year's term of the Supreme Court and its implications on access to federal courts. I'll clarify, the 2014 term ran from last October 2014 through June of 2015. I'm excited to talk to them about those cases, but first I want to let you know how you can participate in this conversation. We host these hangouts to familiarize you in a very casual setting with our authors, with the articles that they write, and with the work that they do, and you have a chance to ask questions or share your own stories with them. So there are a couple ways in which you can do that. If you are watching us through the Google Hangout itself, you can hover your mouse over the left side of your screen, and you'll see a column of icons appear. One of those is a blue box that says Q&A in it. So if you click that, you'll see a chat box open down the right side of your screen, and you can submit your questions to us that way. Don't panic. We won't see your face. We won't hear your voice. Nothing like that. Just your words will come through. If you want to go ahead and try that out now, just to get that channel of communication flowing, please do. You can just send us your name and where you're watching. We would love to hear from you. I know that a lot of you are watching not through Google, but through the Shriver Center's YouTube channel, watching the live stream there. We would also love to hear from you. If you're a tweeter on Twitter, you can reach us that way. You can use this hashtag here, hashtag Shriver Hangout, and we're at Shriver Center. We would love to hear from you as well. All right, without any further ado, we took care of housekeeping, so now let's talk business. So, as I said, this is the latest article in a very long-running series, well over 20 years that we've published these annual recaps of the previous Supreme Court term. It's a big article. It's a meaty article. It's full of a lot of information, but our authors don't want you to be put off by that. And Gary, I'd like to start with you this morning and have you say a few words about these articles and why they're worth diving into and not being intimidated by them.
Well, we have been writing about the Supreme Court's what we call access issues for many, many years now, and we do so specifically for legal services and public interest attorneys. So we do, and our interest is in looking at the way that the Supreme Court, generally on behalf of all of the lower federal courts, interprets constitutional and federal laws to sort of constrict or open up access to the courts particularly for our clients, for poor people, for disadvantaged people who want to vindicate constitutional or federal statutory rights through the federal judicial system. And so we have been monitoring the trend of the Supreme Court now for some decades which in general is a trend that has been restricting, we think, the ability of more disadvantaged plaintiffs to get into federal court to vindicate their claims. And so we try to make it accessible for folks who are like us. We are legal services, public interest lawyers, and those are our clients.
Wonderful, thanks. And I also want to say hello to Matthew in Chicago, who is watching. Thanks for joining us today, Matthew. We're happy to have you. So as the title of this year's article indicates, there were some high-profile decisions last term and some low-profile decisions that all will have some sort of effect on federal court access. I'd like to start with the probably the two biggest headline-grabbing opinions from last term, because they, in addition to their substantive holdings, also will have some sort of consequence on federal court access. Those two big cases are King v. Burwell, that was the Affordable Care Act case, and also Obergefell v. Hodges, which was the same-sex marriage case. I'd like to talk about each of those in turn, and we'll just start with King v. Burwell. So this was the case, so the major holding was that, yes, subsidies are okay for health insurance that was purchased through the federal marketplace. But in addition to that, the court took an unusual approach to deferring to agencies. Gil, can you tell us what the court did?
Well, in a short sentence, they didn't do what they have always said they should do. As many of you know, generally speaking, courts defer to federal agencies' interpretations of statutes that are implemented by regulation. And if the statute's not clear on its face, they go to what's known as Step 2 of the Chevron test. And in that instance, the courts normally defer if the interpretation that the agency is using is a permissible construction of the statute. And that essentially means, unless it's really way, way off, they will defer and uphold that regulation. In this case, they did a strange thing. The court did conclude that the key phrase, exchanges established by the state, was ambiguous, and so they started to go to Step 2 of Chevron, but they did not defer to the IRS interpretation, which is what they have done. That court and many other federal courts have done for 30 years under the Chevron test. Instead, Chief Justice Roberts, speaking on behalf of a 6-justice majority, said that in what he called extraordinary cases where there is deep economic and political significance, courts should not, in fact, defer under Chevron, but should interpret the statutes themselves. In other words, sort of a de novo look at the statute and at the regulation rather than simply saying that looks like a good enough interpretation. And what the majority concluded was that Congress could not have intended an agency in that circumstance to make such important decisions. And by taking this approach, the court did two things. As you know, they upheld the Affordable Care Act interpretation, but they did two things. They insulated that regulation from a change by a new administration. If a new administration comes in and changes the regulation, it's quite possible that even if that change was 180 degrees from the old regulation, the court could simply defer and say it is a permissible construction of the statute. And so the regulation could have been changed completely down the line. But that can't happen now because this court has said how the statute must be interpreted. I think this decision is really important because it may be a weakening of the Chevron test. This may start a process by which Chevron is no longer automatically relied upon every time a regulation is interpreted by a court. Of course, the Supreme Court said here that it was an extraordinary situation, but I think that could be the beginning of the weakening of the Chevron test. So the key thing about King v. Burwell, other than the decision on the merits, is that it may indicate a change in the way courts review statutory interpretations by a regulation.
And Jane, you're at the National Health Law Program, so anything on the Affordable Care Act is sort of squarely in your area of expertise. Do you have anything you'd like to add to the discussion on King v. Burwell?
Just briefly, the decision was important because only 16 or so states have decided to operate their own exchanges. So if the decision had gone the other way, it clearly would have brought the Affordable Care Act down, because people in the federal exchange states wouldn't have been able to get subsidies. I think Gil's point about a potential move away from Chevron is really critical, because when you think about the court's access to court cases, most of them are statutory construction cases. So this has the potential to affect a great deal of what the court's doing. I would also just say that the Supreme Court isn't done with the Affordable Care Act. It has taken its fourth ACA case this year, Beck versus Burwell, which will also be a statutory construction case looking at accommodations under the Religious Freedom Restoration Act for nonprofit entities that don't want to do anything or have anything to do with providing contraceptive coverage under the Affordable Care Act.
You know, this is Gary. If I could just briefly, point out, Chevron is probably one of the most important cases since, in this half of the last century, but it because of its implications for how for the power of federal administrative agencies to enact and guide laws. But Chevron came up in the context of an incredibly technical EPA rule that, if you read through Chevron, it had to do with pollution control devices and bubbles, and it was virtually incomprehensible to a judge or a lawyer or a layman. And the Supreme Court in 86 or whenever Chevron was decided just said, how in the world do we know whether this thing complies with the legal statute? And so they deferred to the EPA. But it's certainly arguable that Chevron's deference is less applicable as a policy matter, where it's simply a legal statute and doesn't involve any particular special expertise on behalf of the agency that is delegated to administer it.
I want to say hello to Maurice, who's joining us from Stevens Point, Wisconsin. So thanks for tuning in today. We seem to have lost Mona's video, but Mona, I think we can still hear you. Is that right? Oh no, maybe we can't hear Mona either. Okay, well, we will pause unless one of you, Mona was going to talk about the Obergefell case, which was the same-sex marriage case, and how it might affect access to federal courts. We could skip that unless one of you want to tackle that one.
Well,
no? Gil?
I could respond quickly on that one. I think what's really compelling about Obergefell, and I really admire you, Amanda, for being able to pronounce that correctly, because many times I say it differently every time. But I think, other than the obviously very important socially and culturally and politically the nature of the merits of that decision, as several commentators have pointed out since the decision came down, this case really sets out a whole new standard for substantive due process. And as the commentators point out, and as Justice Roberts pointed out in his dissent, it essentially overrules the prior decision under which substantive due process was analyzed. I'm not going to go into this in any more detail, but I think it's very important to be familiar with the fact that Obergefell really does change the game for purposes of certain rights and make it possible that rights that might previously not have been recognized will be recognized in the future. And if I could just quickly note two law review articles that you might want to look at if you're interested in reviewing this further. One is 129 Harvard Law Review, page 147, and that's one which really sets out how this works. And then a follow-up to that by Professor Lawrence Tribe at Harvard in 129 Harvard Law Review, Forum 16, and he wholeheartedly agrees with the previous one and says that this really is a game changer. So that's the key thing about Obergefell beyond the importance of its merits.
Right, and I will say Mona has logged off and is going to try to log back in and rejoin us, so we may be able to hear from her on that later in our conversation. So we will move on now, and Gil, I'll head back to you to talk about Armstrong v. Exceptional Child Center. This was another important case. Maybe it didn't grab as many headlines in the mainstream press, but can you tell us what that case was about?
The specific issue there was whether home health providers could invoke the Supremacy Clause as providing a cause of action for enforcing a Medicaid rate-setting provision. And the whole idea of whether the Supremacy Clause provides a cause of action has been percolating in the federal courts in Medicaid cases for some years now. But there had been some clues that maybe the Supreme Court was not going to go along with that concept. And in fact, they did not. Both the 5-justice majority and the 4-justice dissent said that there was no cause of action emanating from the Supremacy Clause. But they also agreed on 2 other points, which are critical and which make this case important for other reasons. And that is that there can be equitable relief even if there is no cause of action under the Supremacy Clause. They didn't really describe where this cause of action comes from. They just said it's a judge-made remedy, and in appropriate circumstances, there may be equitable relief. But the counterpart to that, and again, both the dissent and the majority agreed on this point, is that Congress can limit the availability of that relief if it explicitly says so. And the majority, written by Justice Scalia, concluded in Armstrong that, in fact, there was no right to equitable relief in this case for home health providers. Just one other point on that. That's a lot of important stuff there, generally speaking. But 4 of the 5 justices in the majority, and on this, Justice Breyer did not join the majority, said in dicta that the Medicaid statute itself could not provide a cause of action. And that was an argument that even the plaintiffs didn't raise because I think they were afraid to. But the 4-justice plurality did say that the Medicaid statute could not provide a cause of action. And if they're able to get a 5th vote on that, there might be the possibility that they can eliminate the Medicaid statute as a basis as providing a cause of action. So there's a lot in Armstrong. It's generally bad, but at least the possibility of equitable relief in certain situations still exists.
Jane, this is another case that directly touches on the substance of health law. Have you seen any repercussions from Armstrong already?
We are doing a great deal of post-Armstrong monitoring and advocacy. What we see happening is that, particularly with spending clause enactments, when you're trying to enforce them, essentially what is now the case in terms of trying to bring a equitable court case under the exceptional child reasoning is that you need to show that the 2 prongs are: is there a remedial scheme in the statute, and is there a sense that Congress intends this to be judicially unadministrable? For Medicaid beneficiaries, in terms of this enforcement post-Armstrong, it's not going well. And I think the question is, what is going to happen to this type of enforcement? It could be over. We are left still with the 1983 enforcement, which is an express cause of action when a state is denying individual their rights, privileges, or immunities under the federal statute and laws. The Social Security Act implement laws like Medicaid, of course, are laws under Section 1983. And we're monitoring about 24 cases. Most of them are Medicaid cases, but they're not only Medicaid, SNAP cases, other cases. And so far, with the exception of 1 case from New Jersey, federal courts are not buying state arguments to broaden the reach of Armstrong into Section 1983 cases. So it looks like we're cautiously optimistic that even though 1983 enforcement has been restricted and is more difficult, Armstrong is not going to work a sea change there.
Okay. Well, I want to remind our viewers of a couple things. First, we would love to hear your questions. If you have a question about any of the cases we've discussed, or possibly even a case that you found particularly interesting from last term, let us know. You can do that by opening the Q&A app through the Google Hangout, you can hover over the left side of your screen and click that blue Q&A box, and you'll see a chat box come up. You can send questions that way, or you can tweet them to us. You can use this hashtag here, Shriver Hangout. I see that Mona has attempted to rejoin us. Mona, can we hear you now? No. Oh, that's really disappointing. Mona, I'm sorry we're having those technical problems. This is the beauty of a live broadcast, right? Jane, I'll stick with you then. Oh, one other thing I did want to remind our viewers, you will receive an email after the Hangout today. Probably will come early next week. You'll have a link to this recording. You'll also have a link to the article that my guests have written, and so be on the lookout for that. You can also find it here at this address, povertylaw.org/clearinghouse. It's our main clearinghouse article for this month. You'll find it there. No subscription required anymore. So Jane, another question for you. Statutory construction is something that's always going to come up during a Supreme Court term. Was there anything unusual or remarkable about statutory construction from the Supreme Court last term?
Well, other than the case that Gil discussed, King v. Burwell, a lot of the statutory construction cases were business as usual. One quick case to mention is Yates versus United States. In that case, Mr. Yates, a fisherman, was bringing a cache of fish into shore, which were too small. A federal wildlife officer caught wind of it and gave him a citation for throwing those fish overboard and replacing them with bigger fish. He then argued that, and he was charged with violating the Sarbanes-Oxley Act, which you all remember from, I think it was Enron or one of these scandals, prevents or makes it a crime for someone to knowingly destroy a record, document, or tangible object with the intent to impede a government investigation. So the court was really focusing on whether these fish were tangible objects. And the reason to mention this case is because Justice Ginsburg's opinion for the majority really gives a little small treatise on the various rules of statutory construction that courts will apply. Courts, everything from words typically take their dictionary meaning to words should be interpreted by the company they keep in terms of their placement in the statute. They even look to the title of the provision that was being enforced to reach the conclusion that these fish were not tangible objects, because they felt that read tangible objects so broadly would mean that the words document and record didn't have any place and any role in the statute. But the best part of the decision is Justice Kagan's dissent for the majority, which she said was going on a fishing expedition to find a way to reach its conclusion. And rather than turning to the dictionary, which this Supreme Court is particularly prone to do, she actually used Dr. Seuss's one fish, two fish, red fish, blue fish to support her and the other dissenters' decision that the fish was a tangible object and the phrase should be given its ordinary meaning. I really wanted to bring a copy of the book to hold.
Here you go, Jane.
There it is. There it is.
Yes, I figure I should put this right on my shelf by Learned Hand and Oliver Wendell Holmes. This should just go right in there in the canon.
Or you could just replace Black's Law Dictionary with it, I think. It's a much smaller volume.
Exactly. Better illustrations as well. Gary, I want to turn to a bigger picture question now, sort of with a long view at this. Have you seen any long-term trends while you all have been doing this for over the past couple of decades, monitoring the court? Have you seen a long-term trend with regard to access to the federal courts?
Well, I think if you sort of take a longitudinal view or an historical view of kind of the history of what the federal courts have, what their self-identity has been really up until the middle of the 20th century, the federal courts were sort of legal backwaters. They handled mostly, garden variety tort claims that happened to be disputes between citizens of different states, or they would do the occasional like railroad liability case or bankruptcy. But it wasn't until the 50s and 60s that you got this explosion brought by public interest lawyers, like presumably many of the folks who are watching this, and legal services lawyers, that brought to the federal courts constitutional claims and disputes over federal statutory rights, really for the first time in the court's history in that volume. And the courts loved that. I mean, the judiciary as an institution, that became their self-identity. And I think it still is for the most part. But since the 1990s, certainly, well, probably since the 80s, there has been a gradual concern. Some of it is efficiency concerns. The Supreme Court looks at itself as sort of the gatekeeper for the rest of the entire federal court system. So you had Justice Rehnquist as Chief Justice even before Justice Roberts, going to Congress repeatedly and asking Congress to do things that would sort of cut down on diversity jurisdiction cases. Federal courts don't want to be resolving, those kinds of disputes. That's not sort of their self-identity anymore. But then, on a more sort of ideological basis, since the 1990s, as this court has grown more conservative, they certainly have cut back in a variety of ways with respect to people's access, in terms of restricting private rights of action under statutory, restricting the ability to go in, as Jane was talking about, under Section 1983 to vindicate federal statutory rights. And I think that's a general tendency, and it happens in cases that don't really have an ideological substantive content to it. Just this, one of the first decisions of this term was the court's unanimous decision to not allow a lawsuit in federal court in the United States by an American citizen who was badly injured in a train accident in Austria or somewhere, and the court said that there's no jurisdiction, there's no federal jurisdiction. Again, that's a more general example of the court's increasing tendency that we have seen over a long period to restrict the ability of people to gain access, of plaintiffs to gain access on a whole wide variety of claims.
We're nearing the end of our half hour. This always goes so quickly, but we did just receive a question from Mark. He would like to know if there were any highlights during the term on organizational standing.
I don't think there were any. I don't recall. Oh, wait a minute. There was one. One very important one. Sorry. Let me see if I can find my notes on that. A case called Alabama Legislative Black Caucus versus Alabama. And the short of it was that the three-judge district court from which the appeal was taken had sua sponte determined that one of the organizational plaintiffs did not shown essentially that it had members in the particular district which would demonstrate injury and therefore standing. But the five-justice majority decision by Justice Breyer did a very interesting thing. He inferred from the record that it was highly likely that the conference, the particular organizational, had members in affected districts. But more important, he rejected the idea of sua sponte action in that context. He said if the court was inclined, the district court was inclined to throw it out on standing grounds, it should have given the plaintiff organization an opportunity to show that in fact it had members who were affected and harmed by the policy issue. So I think that's something that could be useful down the line when a court tries to throw people out on organizations out on standing grounds. They should have a chance to come back and say, yeah, we can do that. Needless to say, Justice Scalia did not like that concept very much.
And I will remind everyone that the article that we've published, of course, has all the citations to these cases and goes into a lot more depth on these cases we've talked about today and several others. You will receive that link in the follow-up email to the Hangout, probably early next week. One last question, just quickly, Jane. I'll throw this one to you. What do you anticipate coming from the court this term? Any cases in particular that you're watching, any issues?
Well, I think that it's going to be sort of a soup to nut year at the Supreme Court in terms of access to court cases. Everything is there, from arbitration to standing to potentially consent decrees. Just very quickly, a couple of cases, very important cases to watch. Campbell Ewald versus Gomez. This is a situation where an individual sued on behalf of a class. He was offered a settlement. He rejected the settlement as overly vague and insufficient. Now the company is arguing, and the Supreme Court is deciding whether, regardless of whether Gomez accepted the offer, it has mooted the entire lawsuit, class action and all. Another case, Spokeo versus Robbins, is a situation where the company was giving information, personal information, for example, to employers doing employee checks. Mr. Robbins found out inaccuracies in his information and sued on behalf of a group. And the question there is, sorry about that page in front of me, whether there is standing under Article 3 because Robbins did not allege a sufficient enough injury in fact, but rather was only alleging an injury in law. And I think if you're interested in this Article 3 standing issue, the place to go is the United States brief supporting Mr. Robbins, because it lists a number of the statutes that could be affected by this decision if the court draws this injury in law versus injury in fact kind of distinction. I would also just mention earlier this week, Justice Breyer wrote for the court in an arbitration case that once again recognized the very broad application of the and preemption by the Federal Arbitration Act.
Well, thank you so much to the three of you, and to Mona, who has gone off to the land of silence, unfortunately, but I appreciate all of you, so thanks very much, and thanks to all of you who have joined us today. One other thing that will be in that follow-up email is a link to register for next month's Hangout, and I encourage you to join us for that one. We'll have another really good conversation then. I'll have three attorneys from the National Center for Law and Economic Justice. We'll have Gina Mannix and Mark Cohen and Greg Bass, and we'll be talking about due process in this new era of modernized delivery systems for public benefits, so things like TANF and SNAP and Medicaid, and how due process comes into play there. So it should be a really interesting one. That's also the subject and the authors for our next Clearinghouse article, which should be on the site the first week of January. So I encourage you to check that out as well. Next month's Hangout will take place on Wednesday, January 20th, and it will be at the same time as today's Hangout. That's 1 o'clock Eastern and 10 o'clock Pacific. So please register for that to learn more about due process and modernized systems. So I'll thank you all again. Thanks, Jane.
You're welcome.
And Gary.
Thank you.
And Gil.
You're welcome.
And to Mona out there. And in the meantime, we at the Shriver Center wish all of you a happy and healthy new year, and we will see you in 2016.